Okay, welcome to all of you to our mini IP Talk series. So this is our mini IP Talk tour. We are now landing in India. So join us to learn more about the trends and IP system in India. To those who are working, really thank you very much for joining in our talk. So we hope to finish this webinar before the rush hour begins in Malaysia. In India, it's currently 2 p.m. now. All right, we are so happy to have Mr. Satish Kumar with us this evening. Mr. Satish is an advocate at IP Lead based in Chennai, India. So Mr. Satish has many years of experience in the field, and his firm mostly handle IP cases. Okay, Mr. Satish IP law firm. He handles mostly IP cases, and he's called before the court a lot, really. So we are really grateful to have him with us today. And for your information, this talk is currently live on Facebook. Yeah, this talk is currently live on Facebook. So for those who didn't make it to register for the talk, you can share this to your friend, screen cap this screen, and share. They can join the webinar by going into Zoom, keying in the webinar ID and password, or visit our Facebook page at www.facebook.com/nbsmy to watch the live. Yeah, it's currently live now. Quickly do it, screenshot and share to your friends who were unable to register for the Zoom webinar. 10 seconds for you to do that. All right, 10 seconds is up. So, Mr. Satish, let us invite Mr. Satish in. Can you please unmute yourself?
Yeah, can you hear me?
Yep. Can everyone hear Mr. Satish? Please raise your hand, please. All right, very good. Mr. Satish, they can hear you and see you or not. Let me stop the screen sharing. Yeah, okay. So, Mr. Satish, thank you for joining us this afternoon, yeah?
Pleasure.
We're really glad to have you. And I think the audience would be really interested to know about the IP activities in India. Like, are there many filings in India? How is it like?
Yeah, there are. In fact, we are about 1 lakh trademarks are being filed each year, and about some 20 to 25,000 patents are being filed each year. The copyrights and designs, we actually don't have the numbers for the current year, but they should also be around 10 to 50,000 on an average each year.
Okay, what about applications going out of overseas applications going into India? Do you guys receive many of that?
Of course we do, because probably we are, in terms of population, we are the second. So apparently we have a lot of scope for everybody to come into India. So practically any big corporation that has its activities overseas would definitely look at India as a possibility, and most trademarks that are registered in the parent country of any organization is also filed in India, and so are the cases of patents, because you cannot ignore India anymore if your IP or your business has to go together in the world.
Mm-hmm. Just now you did mention there are 20,000 patent cases in India, right? So
right.
Since there are so many cases, how long do they actually get approved, or to get the first examination report for, let's say, patents and trademarks?
In trademarks, you will get your examination report probably within about 1.5 months maximum. But as far as patent is concerned, because that's more, more structured, where you have to probably wait for about a year and a half for you to get the first examination report, because there are some procedures which we will probably talk about where patents are involved, where you need to seek for an examination, and only thereafter the patent office examines it and then sends you the first examination.
I see. What about language-wise? Like, because we know India has its own language, right? There are quite a number of languages in India. So, for example, if we have a trademark coming from China bearing Chinese words, so how is it like? Do they have to be translated or transliterated into Hindi, for example?
You can actually translate it in English also. But if it is in any other language other than English, the trademark application would have to be definitely translated into English.
Ah, I see. So what about the official language to file for IP there? I mean, do you get more of English or more of your national language?
I haven't seen a patent application filed in any other language other than in English.
Oh.
And probably after the British, we are probably the custodians of English as a language. So mostly it happens in English. I mean, 99.5% it happens in English. And definitely all the applications are filed in English. Wherever you do it from, whether it is online or offline, English is the official language for all the IPR related activities in India.
I see. That's very similar to Malaysia because we are also a Commonwealth country. We practice common law as well. And although our national language is Malay, we receive most of the applications, for example, patents in English instead of our national language. Yeah. So the similar is happening in India, right?
Yeah, I mean, we almost all the Commonwealth countries have to have that as a common pedigree. So it does happen, yes. Mostly it happens in English only.
All right, understood. Thank you, Mr. Satish. So without further ado, let us proceed with Mr. Satish's talk. So I will now pass on the mic to Mr. Satish, yeah? Yeah, Mr. Satish, please carry on.
Yeah, thank you. I will just share my screen for you. Can all of you see that?
Yep.
Yeah.
So for the attendees, please pin your screen. Right click on Mr. Satish's screen and pin it so that to fix your Satish talk. And there will be a Q&A session at the end. So if you have any question, please reserve it or key it in a box and we will answer it at the end of the webinar, yeah? So now, Mr. Satish, the floor is yours.
Thank you. Thank you, Max. Speaking of IP law in India, we actually go back a very, very long time because practically the British has ruled India for nearly 200, 300 years. So with the British, we borrowed lots of the British legislations also. And one of the most important legislations that the British legacy gave us was relating to intellectual property. The first intellectual property law as such in India was in the year 1911. It goes back to the Patents and Designs Act of the year 1911. And we had the Trademarks Act of 1940. But after independence of India in 1947, we overhauled our IP laws so that our local flavor is added to the country's laws, and thereafter we have amended and we have brought out new legislations as far as our national laws on IP are concerned. But before we go into these nitty-gritty details as to what those laws are, let's understand the brief outline of what we call IP. In IP, or it is IPR as it is mostly called across the world, we actually have the four major players and the other minor players. The major players are trademarks, which deals with the origin or the trade source. We deal with patents, which deals with invention of a product or a process. And we deal with copyrights, which is anything which is fixed and which is out of which is original work. And we have the industrial designs, which are essentially the way a product appears physically to your naked eyes. So these are the four major intellectual property laws. We also have the Geographical Indications Act or the law in India, where the products which have the base from a particular territory and the geography of that place gives a particular flavor to the end product is a geographical indication. And after Europe, India is probably one of the biggest users of this particular branch of law. And we also have the other intellectual properties laws like the Plant Varieties and Farmers' Rights Act, the Semiconductors and Integrated Circuits Layout Act, etc. All these form part of the IPR laws across the world, and so it is in India. We do not have legislations for certain subjects which are classified as intellectual property laws, like trade secrets. We do not have any legislation for trade secrets. We do not actually have independent legislation to protect the trade dress, which is part of the trademark law itself, but there are legislations in some of the countries for trade dress, but in India, we do not have a standalone legislation for that. So broadly, if we have to look at these would be the laws that govern the Indian territory. The oldest act that remains in force as of now is the Copyright Act of the year 1957, followed by the Trademarks Act, the Patents Act, the Designs Act, the Geographical Indication, the Biological Diversity Act, and the Protection of Plant Varieties Act. This set of legislations form the bouquet of what we call the intellectual property regime in India. So these would be the laws, and these would be the laws within which we will have to fit in for any person, an Indian national or a foreign national, to have a right within India. And of course, I would assume that all of you would be aware of the fact that intellectual property as such is always territorial in its protection. That is, if you have a registration in India, it protects your rights within India. With that registration, you cannot seek protection outside the territorial waters of India. So it is all geographical in that sense. So all these laws that you see on your screen are essentially protection offered and given within the territory of India. So just like we were discussing a little while earlier, the laws as regards trade secrets and know-how, which could be traditional knowledge also, though there is a traditional knowledge bank where we have certain infrastructure in place to protect the traditional knowledge that has formed part of the Indian culture and its practice. We do not really have a legislation of sorts to protect them. But broadly, what you must understand is, except for patents and industrial designs, the major intellectual property laws do not even require a registration. The rights in an intellectual property, in a trademark or in a copyright, is always available to you the moment you start using a trademark or you create a copyrightable work. So that is something that you can keep in mind. So there are laws, just as a friend was discussing just before I went online, the fact that we are all Commonwealth countries has given us a legacy of what is called the common law. The common law is something which is based out of common sense, based out of judge-made legislations, where the issues were regarding equity, good conscience, and so and so. So irrespective of the fact that there are legislations there, that there are laws which give you a framework of what is a trademark or what is a copyright, if you have a right which is worth protecting, it is worth protecting under common law also. In fact, the place where I come from, Tamil Nadu, and one of the oldest high courts of the country, Madras High Court, is here, where in the year 1967, there's a beautifully given phrase in a judgment of the Madras High Court on the copyright law, where they say whatever is worth copying is worth protecting. So at the end of the day, what we need to look at is it worth copying? If it is worth copying, it is worth protecting, especially with relating to laws like trademarks and copyrights, where it is beyond just the framework of the written law. So wherever we do not actually have the benefit of a legislation, we can still be able to protect those laws also on the basis of common law. As far as legislations are concerned, these are it. And you have the unregistered intellectual property rights and the registered intellectual property rights, and the broad governance are what we have seen here. As far as India is concerned, it's practically the signatory of all the intellectual property related agreements, whether it is right down from the WTO to TRIPS and the Paris Convention, the Berne Convention, which are even which are much prior to the WTO and its existence. In fact, India signed the WTO agreement in the year 1995, and we had a 10-year leeway before 2005, where we could amend our laws in tune with the general obligations given under the WTO. So that time has long since gone, and we have actually given our laws, in fact, the Trademarks Act and the Patents Act were the last two to be amended. In fact, the Trademarks Act, though was passed in the parliament in the year 1999, came into force in 2003 in India, and the Patents Act was amended just in the nick of time in 2005. And there's a very interesting history also in that amendment, where we have introduced one particular provision in our Patents Act, that is the Patents Act in India, which was subject of a huge controversy across the world. And what happened to that is a very interesting history in India as far as patent law is concerned. But as far as the treaties are concerned, the last thing to come into force recently was the Madrid Protocol, which came into force in the year 2017, where we can now file applications from one jurisdiction, that is from India, across the jurisdictions of all the signatories of the Madrid Agreement through the Madrid Protocol route. That was the last of the treaties, international treaties that have come into the Indian legal system. So today we can definitely say that we are at par, and that is one of the beauties of intellectual property. Though the principles of many laws remain the same across continents and countries, the law relating to intellectual property is decidedly singular. We are almost at par with every other country. So it is now not possible for you to have a different standard of protection, different definition of what your trademark is or a patent is, and so on. So essentially, practicing or prosecuting the Indian intellectual property rights is very easy if you know your local intellectual property laws. The differences may not be huge, except in some cases the differences could be very telling. For example, in the Indian patent law, we do not give patent for softwares per se, whereas in some jurisdictions, only softwares per se are given patents, whereas we are protecting software only through the copyright route in India. So there will be some differences which could be small in some cases. In some cases, it could be huge, but those differences are few and far between. The intellectual property laws in India are at par with probably the world intellectual property rights today. Now, the other treaties that we have signed, which are also important, is the Nairobi Treaty, the Washington Treaty, etc. And the last thing to be signed is the Marrakesh Treaty, which is access to the works to visually impaired persons and persons with disabilities. So to bring that into our legal system in the year 2017, there were some amendments to the Copyrights Act where they said there are certain materials which have to be available in Braille and so on. So the Marrakesh Treaty comes into the Indian legal system through those amendments of the Copyright Act. So broadly, this is how the Indian law has now become part of the universal laws of intellectual property. Now, the practice part of the intellectual property is broadly under the category of the Ministry of Industry and Commerce of the Indian central government. We have a unitary form of government as far as certain subjects are concerned. So the Commerce and Industry is essentially headed at the Union Government of India, where we have the rules across all the states, which are equal to all the states. And the Department of the Industrial Promotion and the Internal Trade, which is otherwise called DIPP, is the governing body for all the intellectual property laws. And the prosecution part of the intellectual property laws is headed by an administrative officer who is essentially a central government servant in the administrative service cadre. He is officially the Controller General. He is the topmost as far as IPR registration and the offices of intellectual properties are concerned. He is the Controller General of Patents, Designs, and Trademarks. You might wonder why copyright is not there. Copyright was under a different ministry for a long time until 2019, where it was under the Ministry of Human Resource Development, which was also merged into the Controller's Office. So practically today, the Copyright Office is also under the control of the Controller General of Patents, Designs, and Trademarks, though the definition as such has remained unchanged. Under the Controller General, we have different officers and different designations across different parts of the country to facilitate jurisdiction, because India is geographically a very big country. So we actually have trademark offices, patent offices, etc. in 5 jurisdictions, which is spread across the north, south, east, west of the country. The place where we are from, Madras, as it was called, Chennai today, we have the patent office, the trademark office, and the head office of the Intellectual Property Appellate Board, which is the head office for the entire country, are all within the state of Tamil Nadu, or in the city of Chennai, which is where we come from. So the personnel and the broad outline of the offices dealing with the intellectual property rights are as below, and the geographical locations are given there, just to drive home the point that because it's a huge country, we need different jurisdictions, but the common head, the administrative head of the entire region is situated in Mumbai, where the Controller General sits. So the city of Mumbai is where the Controller General's office is, who has a general administrative control across all the intellectual property offices in the country. Now, as far as prosecution is concerned, I will take each intellectual property separately and tell you what needs to be done to have an intellectual property registered in India. Trademarks being the most often used intellectual property. In fact, there was a interesting survey conducted about 5-6 years back, where the number of trademarks involved in a day-to-day life was given by an American agency which conducted that survey across the United States, and it came out with a number which is 15,000 a day. The number of trademarks that we encounter on a single day for an average person is about 15,000. That's a huge number. So naturally, the number of trademarks filed and the number of trademarks prosecuted and the number of trademarks litigated would naturally be more than any other intellectual property. So what are the documents, the details that are required for filing a trademark application in India is given here. As you should be aware, trademarks can be filed both for goods and services, which is part of the WIPO agreements and the TRIPS agreements, where that has also been brought into the Act now. Previously, the goods alone could be registered in India, but after 2003, that is today, we definitely can register both the trademark for goods and the trademark for services. Crucially, the Trademarks Act in India does not use the expression service mark, though it is very liberally used by many people to define trademark for services. The definition here is trademark for services, not a service mark. But be that as it may. So whether it is a trademark for services or a trademark for goods, the documentation required is just this. So we would definitely require the trademark, whether it is a word or a label, etc. If it is in color, you have a certain limitation as to the registration, which would be for that particular color only. So you would have to necessarily decide whether you are going to file an application in color or in black and white, etc. Whatever the label is, we need a copy of that label, and that can be in a JPG format, which could be uploaded online. If it is a physical filing, which we can just take a printout in color or black and white as per the advice of the clients. But if you file it online, it has to be in JPG format. There is no other format which is accepted by the trademark office websites. The second most important thing that we require is the details with relating to the applicant of the trademark, and the details as in the names, addresses, etc. And if it is a partnership firm or a LLP, the names of the persons, especially if it is a partnership firm. The process in India while filing an application for a partnership firm would be A, B, C, D, the names of all the partners, any number of partners there may be, all trading as the partnership firm. So we need the permission of all the partners. The permission can actually be signed by one, but the names of all the partners would be essential for us to file a trademark application. If it is a legal entity like a company, there's no difficulty. The company's legal entity, the registered office, and that name should be sufficient. If it's an individual, whether he's trading on his individual name or as a proprietary concern would have to be mentioned. So those basic details as regards who the trademark applicant would be is essential. And the most important aspect while filing a trademark application would be to give a date about the use of a trademark. There are two ways in filing a trademark application in India. One, it could be a use based on a proposed user basis. That is, I'm not yet using the trademark, but I will soon do so. So it could be on a proposed based use. Or if you actually are using the trademark for a while and thereafter you want to file a trademark application, then you need to give the exact date from which you are claiming a right. And that is most important. And those dates must be proved by some documentary evidence, the dates, the documents, along with an affidavit on oath stating that this trademark belongs to me. I have been using this trademark from these dates, and this is the proof for the use of the trademark. All these details would have to be given by the applicant if the user is earlier than the application. So that supporting affidavit, along with the documents of use and the authorization for engaging a trademark attorney or an agent, would be the documents basically required for filing the trademark application. The official fee is too tired, where individuals are treated in one way and the entities are treated in another. The individuals are essentially given a liberty to pay a lesser fee, whereas a legal entity is charged a bit higher fee. The fee details are given there. It's approximately about $70 to about $140 for filing a trademark application in India. And if it is a company which is a medium or a small enterprise registered with the respective government, then they are treated at par with the individual and the fee is only 50%. In this fee that you see on the screen, there is also a 10% reduction if you use the online filing. So you will also have that bit of advantage while we file it online as far as trademark application is concerned. Now the process of trademarks, I'll come in a while, but before that, we'll just go to the documents required for filing the copyright application. Now, copyright is a very wide right. It is given for many subjects or works, as it is called under the most copyright legislations. It could be literary work, artistic work, musical work, or a cinematograph, film, etc. The work must be given in a visible, final, verifiable form to the Copyright Office for filing. So it could be in the form of a pen drive, it could be in the form of a compact disc, or if it is a literary work in the form of a book or something, it could be a bound volume which can be given to the Copyright Office. But that's an essential thing that the Copyright Office demands as far the work is concerned. Now here again we have about three forms. Three forms basically contains details as to who the applicant is and who the author is. there is a slight difference as far as copyright law is concerned, which is not there in the trademarks law. The trademarks law, you can apply a trademark whether you are a manufacturer or a trader or a dealer or a distributor. You can have a trademark on your own in wherever the chain of the service you are. But in copyright law, there is a difference between the author and the owner, who will essentially be the applicant. The author is the person who creates the work, whereas the owner is the person who ultimately has the right. And the Copyright Act across the world, and similarly in India, makes a distinction between these two people. The author of a person who is engaged as a contractor, for a contract of service, essentially makes the work. So he will be the author, but he will give the work, or he will do the work on behalf of someone else, and that someone else will be the applicant. But the determination of who the author is and who the owner is essential under copyright law, for the reason that the protection, the time limit for protection is determined not by the owner or the date of filing, but by the date of the author. Because the protection of copyright across the world is the lifetime of the author plus 60 years from his death. So that is why the determination and giving the details as to who the author is in a trademark application, in a copyright application, beg your pardon, becomes very crucial. So just like the owner, the copyright application will contain the details of the applicant, his nationality, his place of business, etc. So it is the case with the owner. And what is important, just like use in the trademark application, is the date of publication of the copyright. Here again, just like trademarks can be applied as a proposed to be used, copyrights can be applied for unpublished works also. But if you have published it, then you shall give the names of the publishers, the date of such publication, and these would be the details in the form which you file for trademark application, along with, of course, the authorization authorizing the attorney to file it on your behalf. There is one extra document as far as copyright filing is concerned, which is the no objection certificate, which you would be requiring from the trademark office. Because if you broadly understand the trademark law and the copyright law, there is a huge nexus. What is an artistic work could also be a label or a logo of a trademark. So what could be copyright could also be a trademark. So to avoid a conflict where one person having a trademark as a logo, whereas the other person has a copyright for the identical artistic work, to avoid the conflict between these two equal rights, there is a methodology adopted in the Trademarks Act and rules, where if the label that you apply as an artistic work is capable of being used as a trademark, then you shall have a search caused by the trademark office, and the trademark office shall give you a no objection to go ahead with the registration of the copyright. That application can be filed before the trademark office. The cost is mentioned therein, about 70 to 80 US dollars. And that no objection certificate must to be filed along with the copyright application before the copyright office for them to process it. So that's the basic nexus between the two legislations. And the fee independently, as far as copyright application is concerned, ranges from about $7 to $8 for a literary work to 5,000 rupees for a or 70 US dollars as far as softwares and cinematograph films are concerned. So the rates depends on the actual work that you want to register as a copyright. So that is as far as copyright is concerned. Now, as far as design is concerned, it is, as I said, it's a it's the external appearance of the article. And essentially, because we will be filing this application in a piece of paper, it graphically, we would have to file the object, which is a subject of design, in different perspectives. Like if you take let's say a mobile phone, you will have a top view, you will have a bottom view, you will have a side view, you will have a perspective view, and so on. So that the officer in charge who is looking at the paper will have a basic idea about how the article will look 360 degrees, and therefore determine whether it is a subjectable design, whether it is a registrable design, etc. So to that extent, for filing a design application, the work involved would have to be photographs essentially in different shapes or in different angles, so to speak. And the application is a very simple application. It is a simple one-page application where the application will contain the claim made with relating to the shape or the configuration of the article on which the design is applied, and also a disclaimer stating that the functional features will not be claimed as a design right, which is the law basically. So you would have to reiterate that law in the design application also. The fee, as far as design application is concerned, is about $140 US. And the procedure involved here is where after the scrutiny of the trademark application, if there are any defects, those will be pointed out to you. And once you communicate and successfully answer those objections, the design right would be granted. And design right is by and far the shortest intellectual property right available. It's only 15 years. And thereafter, the design falls into what is technically called the public domain. That is, it is free for use by any person as far as design is concerned. As far as patent is concerned, which is probably the more elaborate documentation in terms of intellectual property law, but practically it is only one single document, which is what is called your specification. Your specification could be a provisional specification or a complete specification, depending on the completion of the invention. But the patent application per se becomes complete only after your complete specification is filed. And your complete specification is the entirety of your patent, in the sense that you cannot deduct or add anything to your patent apart from your complete specification. So that is why it is always termed as a technical or a techno-legal document. So it requires both legal inputs as well as technical inputs. We need to understand what will stand the legal scrutiny and what will stand the technical scrutiny without losing the ethos of what the invention actually is. So without compromising on the invention, the document has to have the background of the invention, preferably so that you will help the examiners appreciate the need for the invention and the inventive step more clearly. So if you actually say that people used to have leaves to cover themselves before umbrellas were invented, and now I have invented an umbrella. So it makes sense. So it will make the examiner appreciate the invention much more clearly and in much better light. And it also helps in streamlining their search. So it is also a way in which you direct them to search towards a particular sector of inventions and make them understand how your invention qualifies to be a patent. So background of the invention is an essential part, and the alternates that were available, which is what is called, both of these things are what is called the prior art. So if your invention is hit by what is called the prior art, there is no patent. If it is over and above, or if it is beyond, and if it has an inventive step over whatever was available as a prior art, then you have a patentable invention. And what you do, in fact, that is where the most important piece of advice would come from experienced patent filing agents or attorneys. You must describe your invention very clearly. If the description is insufficient, your patent can be rejected, even if you have a good patentable invention. And that is part of the law, not just in India, across the world, where if the patent is insufficiently described, the patent can be refused. So please keep in mind this basic features. And ultimately, what you get as a patent is what you claim. The end of the patent filing or the patent specification, you will have the claim set. There will be a principal claim, a subordinate claim, or a independent claim and a dependent claim, so on. Whatever it is, the set of claims. The set of claims are your rights. There is nothing more to your patent. You cannot add even a comma or a full stop or any punctuation for your claim while you are claiming a right on the patent. So your claim is again a piece of draftsmanship where you need to really be careful in drafting your claims correctly. And just like copyrights, in patents, we have two people. It is the inventor and the applicant. The inventor need not always be the applicant. The inventor could be an individual, has to be an individual essentially, whereas the applicant need not be an individual. So the inventor would have to also permit the applicant to file that patent application. In fact, we recently had an experience where one of the patent filed was refused registration because one of the inventors, there were 5 inventors, because one of the inventors had not signed on the application. Even that is a ground to refuse a patent. In fact, unfortunately, that was a patent which was where registration has been obtained by that company in about 12 countries, whereas in India it was refused for this technical reason. So it is both a legal document as well as a technical document. So we'll have to be careful on these aspects as well. Filing a fee, again, it is two-tiered, where one in terms of individuals and small entities. In fact, there is a 3-tiered fee structure as far as patents are concerned. There are, if you see the screen, I've given 3 different prices. So the 3 different prices are basically the fee which is paid. The first is by the individual, the second by the small entity, and third by a legal entity. A small entity could be a one-man company and so on, whereas a company per se would be charged at the highest price point. So the details are there. Expedited examination is possible as far as trademarks are concerned and patents are concerned, depending on the urgency of getting the registration, we can use it. The request for publication is a regular process. The request for examination is another process. So until the patent is examined, you would not get a first examination report. So it also depends on your application for examination of the patent. So you would have to file it at the appropriate stage where the patent office will take up that application, then scrutinize that application and send you what is called the examination report. The examination report is followed by a personal hearing if necessary, both under the Trademarks Act as well as under the Designs Act. And on overcoming the objections raised by the respective officers, the right of a trademark or a right of a patent is granted. Most of these rights are time fixed. Patent, there is an annuity to be paid to keep it alive for the maximum period of 20 years, whereas trademarks do not actually have an expiry date. as in that no trademark goes into public domain unless the registered proprietor does not use the trademark. But there is a renewal process in trademark which you keep renewing every 10 years once, and it is up to the registered proprietor to keep it alive and fine for as long as he wants. In India, there are trademarks which are as old as 160 years. Trademarks have been in use continuously. In fact, I believe the product Mysore sandal soap is also exported to Malaysia. Mysore sandal soap is 153 years old as on date, continuously being used. So there is no expiry date for trademarks, whereas patents are confined to a life of 20 years. That is now at par with across the world, and after 20 years, it falls into public domain. Anybody can use the patented invention, and there is no longer a risk of infringement after 20 years in a patent. Now, that is as far as the prosecution aspect of patent is concerned. I've just given the brief flow chart as to the patent application process is concerned, which we have just discussed now. The legal framework in India, that is post the registration, post the prosecution of the intellectual property rights, the most crucial aspect in intellectual property is its protection. You do not protect an intellectual property, it is as good as not having it. How do you protect an intellectual property in India is broadly what we will see from now. Apparently, the judicial process is there. There are quasi-judicial bodies which also protect the intellectual properties. The mechanisms of the trademark office, the patent office, or the design office, or to a limited extent the copyright office, where they send you the scrutiny report, is the first level of legal protection offered to a registered proprietor. Because if your trademark is registered earlier, the trademark office will say there is one person who is already registered, so therefore I cannot give you that trademark or a patent for the same invention. Where if you cross that threshold, it is still published. They are still published in the Gazette of India, which is open to all and which is part of the professional job of a patent attorney or an intellectual property attorney to look into those aspects and advise clients accordingly, so that they keep what is called the opposition procedure. You can oppose a trademark which is similar to yours or identical to yours from being granted registration to another. Similar is the case with patents, where that is the first level or the first threshold where you can object to your intellectual property being violated. So that is the step one which happens within the intellectual property offices in the country. But this presupposes a fact that the infringer or the so-called would-be infringer approaches the patent office. So, or the approaches the intellectual property office. If so, then fine. But most infringers, as you would all agree, may not even reach the doors of the intellectual property office, where they will just copy the trademark or a patent or a design or a copyright and go to the market. So that is where the legal framework steps in, and the quasi-judicial bodies like the police, the customs authorities, who can stop the import and exports from and outside the country, where the police can act only. Remember, the Indian intellectual property legislations give criminal provisions only for the Trademarks Act and the Copyrights Act. Only for these two enactments, you can approach the police. For the patents or the industrial designs, it is not permissible under the law to go and approach the police authorities. though you can approach the customs authorities on certain aspects of the infringement when it happens. So these are the basic quasi-judicial authorities. As far as the judicial authorities are concerned, we have essentially a three-tiered system in the Indian judiciary, which is one within the district level and one at the state level and one at the for the entire country. In the district level within each state, there are two tiers of judiciary, but all intellectual property cases or all intellectual properties laws mandate that it is filed before the highest district judicial officer of that district. So for appreciation of the law involved, the threshold is kept a slightly higher level than a ordinary civil litigation in a court of law. So you can approach a district judge directly. So that is one threshold, then the high courts, and then the Supreme Court of the country. Recently in 2017, India has had a legislation where the intellectual property laws are clubbed into along with other commercial laws, and we have what is called the Commercial Courts Act today. The advantage of having Commercial Courts Act, as we see it on our day-to-day practice, is that there are strict timelines fixed for the process of registration. One of the vexed things as far as India is concerned is the delay in judiciary, which is causing a lot of heartache for many people who approach a civil litigation in India. But the Commercial Courts Act has been enacted in redressal to that grievance. And in fact, the object of the law is to bring in more foreign players into the country, and we are proud to state that we have a timeline now. In fact, as far as Madras High Court is concerned, I had the good fortune of filing the first commercial litigation in the Madras High Court, and we have already finished it, and the appeal is also the one stage of appeal within the High Court of Madras is also completed. So the act as such came into enactment in December 2017. So within 2.5 years, we have had 2 rounds of litigations completed. And I think that is the end of that litigation. But 2 years in a litigation, in a commercial litigation, after examination of evidence, the process of chief and cross-examination, the entire process having completed is, I believe, at par with the international average. So that is something that the Indian courts and the Indian judicial systems has come out with, and the Supreme Court is in its judgments has been extremely vocal in in protecting the sanctity of the legislation. So today, the maximum timeline you are looking at for completing a commercial litigation, which is an intellectual property litigation, is about 1.5 years maximum, or maybe 2 if you are slightly unlucky, but not beyond it. So that is as far as the jurisdiction is concerned. As I was stating initially, India has a very great history of intellectual property, a very great history of intellectual property. In fact, some of the judgments which you can see on the screen are where the intellectual property rights have been upheld and clarified and made for the first time. As far as India is concerned, the history that I was talking about under the patent law is actually this. There is one particular provision in the Indian Patents Act, which is Section 3D, where the particular section was actually for protecting the Indian generic manufacturers, which was objected to by an American multinational giant pharma company. The matter was pending from the Madras High Court. It went right up to the Supreme Court, and throughout our clients succeeded. That is, the Indian generic manufacturers succeeded. There was even a challenge to the provision saying it is beyond the prescriptions of the TRIPS agreement, but even that was not accepted by the Indian Supreme Court. So to that extent, India is a very strong intellectual property enacting country, though America believes otherwise. That is for reasons like these. And the other reason is where one of their companies, Bayer, were on the wrong end of the law, where some of their products which were sold at an exorbitant price for a cancer drug was where a compulsory license was given to a Indian generic manufacturers. So naturally, the 501 list and the other things that the America imposes on India is essentially difficulties between two countries. But intellectual property and its protection in India, I very firmly believe, is in wonderful hands, both from the legal perspective as well as from the prosecution perspective. We have a very robust system in India where the laws are applied as they are and as it should be. There are odd cases here and there where we could go otherwise, but predominantly we have a fantastic system in place. And finally, as far as trends are concerned, which we have also discussed across, so these are basically on the administrative side, and on the judicial side, we have the commercial courts and the enforcement wings that have come about. And basically, intellectual property in India is booming each year. I started my practice about 20 years back. Each year it has only increased. Each year it has only been more good work, more profound work, and more qualitative work. So IPR in India, I think, is a very interesting place to be. And if anybody is looking to invest in India, you can be rest assured that this country knows the value of intellectual property and it will protect your intellectual property. So that will close the session as far as my thing is concerned. If there are any questions that are posted or that can be or should be answered, I can gladly do that. Marcus, over to you.
All right, thank you very much, Mr. Satish. It's been very informative talk from you, and I believe the audience have learned a lot. And it's quite a detailed process about how trademark, patent, copyright, and designs are filed in India. Yeah, so we've got a question in the Q&A box. An anonymous attendee actually asked, may I check if the trademark is general, is it okay to get registered in India?
Yes.
Like a very general word, for example.
No, if I understand the question, it's may I check if the trademark is general? Is it okay to get it registered? If I understand the question is if the trademark is a general word or a common word, can I get it registered? If I understood it correctly. Is that what the question is?
Yeah.
No, you cannot get a general or a common word registered anywhere in the world, and India is no exception. Any descriptive expression is prohibited to be registered as a trademark.
But what if it's general, but it doesn't describe its business? Is it okay?
General like best, laudatory, something like that?
Yeah.
Those are also prohibited. See, the basic objective of a trademark, as we would know, is to distinguish the product from one from another. So if you have a general word which describes your product, it naturally has a bearing on the other person describing his product. So those will definitely be objected to under any law. And in fact, in Indian law, there is one provision where under the Trademarks Act, under Section 9, where it says this is one of the absolute grounds of refusal of registration of a trademark.
Okay, so for example, if you are selling cake, you can't trademark your brand as a cake, right?
That would be a generic expression. It's even worse.
Yeah.
So what will you sell your cake as if I register cake? You can't call it a muffin, can you?
Yeah, can't.
So naturally.
That would be too descriptive, right?
And I also cannot call it good bake or best bake.
Just bake.
So even that would be prohibited.
So for the audience out there, so we have to keep in mind that if you have a mark or you're starting a business with a name, please do not name your business over your product. Okay, don't name your business after what you're selling or providing, right? If you sell an apple, don't call your brand an apple. Yeah, that's what Mr. Satish means. So
yeah, you can sell an iPhone and call it Apple. That's fine.
Yeah. I note one thing that you say is very interesting. Anything that is worth copying is worth protecting.
That's true.
Yeah, because people always copy something that is valuable, right? So when it is valuable to your business, so it is good to get it protected in terms of IP, yeah? Like how you would protect your car from being stolen. Yeah, so just now, Mr. Satish, I have a question. You talk about in trademark, right? Okay, apart from the mark, and we need permission from all partners to apply for the trademark and the authority for the attorney. You also mentioned that we have to submit the date of use or the date of proposed use, right? So this explains in India, do they use a first to file system or first to use system? Like if I use first, it's more important, or I have to file first? Who file first is more important?
Commonwealth. First to use is the most important. In fact,
first to use.
There are judgments of the Indian Supreme Court where we have protected trademarks which were used first, even against registered proprietors.
Ah, okay. So meaning if there is someone who has registered your mark and you can prove that it has been used first, then you can actually invalidate his mark. Is that so? Or
Absolutely.
You can use it together with his mark. Is that so?
Not just invalidate his mark, we can also stop him from using the trademark further.
Okay. But can you use it together with his mark, let's say? Because
he can't question me. He can't question me because I will be the prior user. I'll be the first to use. But if I want, I can either let him live or I can kill him.
Okay, that's interesting.
In fact, I think there is one question on the screen, which is, can you elaborate more on the law of trans-border reputation?
Yep.
I think it's come in the chat box.
The law of
we have time to answer it?
Yep. Can you elaborate more on the law of trans-border reputation? Yeah. Can you explain more?
Yeah, I can do that. See, in fact, this is a concept which is very unique. What happens? How do you create reputation?
How do you create that?
Yeah, exactly the point. So reputation means there is necessarily a product available from your market shelf. So you need to have a product. You need to have bought it several times, used it, and therefore you create a reputation. But even if the product is not available in your country, yet if you know about that product, that is what trans-border reputation is. So trans-border reputation essentially is reputation which is across territories, not just confined to where the products are sold. So, for example, in India, in the late 80s or in the early 80s, we had a policy decision that there will be no foreign brands until the year 1991 when we reopened our stores again. Let me assume that one country is where Coca-Cola is prohibited from being sold. Will a person from that country not know Coca-Cola at all? Will Coca-Cola have a reputation in that country?
Okay.
So that is what a trans-border reputation is. So even if products are not available within one geographical region, if we have reputation that is reaching that region, that is sufficient to protect misuse. Because this is a concept, what happened, the historical background of this is where foreign brands were copied with impunity in one particular territory. So that is to stop doing that. In fact, the example which I had given where Tiger Balm, the famous Singapore brand, was protected in India in 1996. Because at that point of time, Tiger Balm could not be brought into India legally. Yet an Indian manufacturer copied the Tiger Balm so much so, in fact, the judgment actually has it in writing, where they say there was a spelling mistake in Chinese when in the sheet attached to the product. Even that spelling mistake was copied by the Indian manufacturer. So the court said this is an absolutely brazen attempt to copy. And even though trans-border, even though the product is not available in India, the trans-border reputation is available in India and stop the infringement happening in India.
Oh, I see. They could have called it Lion Balm instead of Tiger Balm.
Still, I would have sued them.
Yeah, so it's kind of like the protection of famous mark. Yeah, it's similar to Malaysia. Yeah, so if a mark is so
we call famous
Malaysia,
marks or well-known trademarks. So that is how.
Yeah, exactly. So, Mr. Satish, just now you mentioned that there is something called a pre-litigation process. Pre-litigation, can you explain more? Why is it mandatory and how is it like?
See, under the Commercial Courts Act, if you do not seek for an immediate order, there is a mandate for you to give notice to the other side, the defendant, and they would be brought to the general ages of the commercial court, the court where the litigation is proposed. And there is a process by which where they can try to resolve their dispute. Only if the dispute is not resolved, thereafter the case will be proceeded for trial.
Oh, meaning they have to, any litigation before it's brought to court, they have to undergo something called mediation first, right? Is that what it means?
If you do not seek for an interim order, that's the catch.
Okay.
Understood. So if you do not need an urgent order, then you must go to mediation. If you need an interim order, it is optional.
So it's not advisable to directly bring an infringer to the court.
That's right. That's the. Probably he is unaware. Probably he is just a little avaricious or wrongly advised or such, where it is easier to conclude it without, the full-fledged litigation. So it's just to protect that.
All right, understood. So yeah, that's it for my end. Any other questions from the attendees? Where the time is almost up. Yeah. So we can see how India is very vigilant in protecting its IP nowadays. And we can see also for patent document how punctuation is so important, not just in English, but it's in the patent language, how a punctuation can even affect your protection. Yeah, so it's so important. So there's another question. What about injunctions in India? To stop someone from doing something?
Yes, of course. That's the basic relief that we seek in a intellectual property proceeding, not just after trial, but even before trial, what we call the Anton Pillar orders in common law, which comes from the United Kingdom, where even pending trial, if I can show that my business will definitely be affected if he proceeds to continue to use the trademark, I can seek an injunction which is ad interim or injunction until the disposal of the suit also.
So meaning if the damage hasn't even occurred, but you think that the infringement will potentially cause the damage, so you can seek for an injunction to stop him or her from using your trademark or patent, right?
Absolutely.
Or other IP
In
rights.
fact,
Yep.
Yes, it's what you were referring to, Marcus, is called kaya climate action. So where the infringer hasn't started to infringe.
I see.
Hasn't
Understood.
actually started to infringe. Even there you can stop him. For example, there is an advertisement in the newspaper saying, from tomorrow I'm going to sell this particular phone with a particular brand. If the brand affects me, I can go to the court today and say, stop him from even launching it tomorrow. So even that's possible.
Oh, is it that fast to get an injunction in India?
If you put your mind to it, yes, it is. We can.
I didn't expect that. That's pretty fast. Wow. So you guys are really vigilant.
We can. We have done that.
Yep. All right. Thank you so much, Mr. Satish. Yeah. It seems our webinar time is up. Yeah. Thank you to all the attendees for attending this webinar. And next up, we have a talk. Our NBS Mini IP tour is bringing you guys to China. Yeah. So the next tour will be to China. And it will be held on the 13th of August. It's on a Thursday, 11 a.m. Kuala Lumpur time, all right, and Beijing time. So we're gonna post the update soon. So follow our NBS Intellectuals page on Facebook, NBSMY, yeah. For any inquiry or information about IP protection in Malaysia, Southeast Asia, and throughout the world, you can actually visit our official website at www.nbs.com.my. All right, so we're going to end the webinar here today. So thank you very much for attending this webinar. And thank you once again, a round of applause to Mr. Satish Kumar. Thank you.
Thank you so much. Pleasure always.
All right. Bye-bye. Thank you. Yep.